Okay, so welcome back everybody from lunch. I hope, as I encouraged you, that you all managed to find couscous somewhere to eat. I didn't find, but anyway, welcome back. We have our second panel and they are ready and raring to go. I have put in the chat the names of our speakers, but you can see their names, the link to their bios for you to please go through. The panel, our second panel, will begin to engage with questions about African states. Let me just be sure I'm looking at the right page. Yes, international investment agreements and development of African states. They're going to try to figure out, looking at the various international investment agreements that African states engage with, whether those have any role to play with on the development of African states. They're also going to mention something around the Africa Continental Free Trade Area Agreement. And this panel is being chaired by Thierry Ngoga Gakuba. Everybody knows Thierry because, of course, Thierry was the first registrar of the Kigali International Arbitration Center. So for some of us, we'll say a huge thank you to Thierry for remembering us for those all-important appointments. But right now, Thierry sits more as an arbitrator. He does conducts trainings, and he is, more importantly, he is a partner at Legal Line law firm in Kigali. So Legal Line Partners in Kigali. I have also put in the chat a link to Thierry's bio, but all our bios are on the conference website. So please do look at that. I'm going to hand over to Thierry, who's going to be in charge of the next 2 hours. When towards the end, we will have a poll. So you will have your say. The last, Thierry, I'm not putting you under pressure, but the last panel, they got 100% on both counts. So that puts a little bit of pressure on your panel, but I'm sure we will enjoy your panel as well. At the end of the poll and at the end of this panel, we would welcome Ms. Amani Khalifa, who would speak to us just to remind us about the equal representation in arbitration work that the Africa Subcommittee is doing. Thierry, I'll hand over to you now.
Thank you very much, Emilia, Professor Emilia, and thank you for inviting me to chair this session. This session is titled International Investment Agreement and Development of African States. The panel will be discussed, as Emilia say, the panel will discuss how those identified interests are negotiated in international investment agreement, such as concession contract, regional economic community in Africa, etc. But this panel will particularly focus on the content of international investment agreement signed by African states, and will also explore how content of such agreement can be fairer and more equitable between its parties and beneficiaries. This panel is composed by 4 renowned speakers. The first speaker is Mr. Bobby Banson. The second one is Mrs. Giselle Stephen Chu. And the third speaker is Clara Blirenburg. And the last speaker for this session will be Professor Walid Ben Hamida. To avoid delay, I'm going shortly to introduce Mr. Bobby Banson, who will be the first speaker. Mr. Bobby is a qualified lawyer to practice law in Ghana. He has experience in providing legal advice and service to companies in various sectors of Ghanaian economy and foreign-based companies seeking to do business in Ghana. He is a fellow of the Chartered Institute of Arbitrators and has participated in spoken various arbitration and investment conferences organized by also in several domestic arbitration matters as well as international arbitration cases. Bobby teaches civil procedure at Ghana School of Law and has published several articles. Bobby, yes, I wanted to say Bobby of Ghana. Bobby of Ghana, Banson, will speak on the gap between the terms of treaty negotiated by African states with a trade and investment chapter and will discuss the Nigeria-Morocco BIT as a possible template of BIT for Africa that should have a clear developmental agenda. May I handle this 20 minutes to Bobby? Thank you.
Thank you very much. Thank you very much to the organizers of this conference. It's a privilege to be part of this well-endowed panel, if I may say it that way. And thank you, Mr. Thierry, for your kind words of introduction. Emilia already told us that the panel before scored 100% on all fours. I'm sure time would have scored on all fours with the time. So we would go straight to the point. My task is to speak about bilateral investment treaties as a means of providing a developmental agenda for countries that participate or that are parties to such treaties. For the purposes of our discussions or my discussion, I would want to focus mainly on African countries, either between African countries and then between African countries as host nations, and then the home countries of investors, which are outside Africa. I would want to start with a general concept before I narrow down to the Morocco-Nigeria BIT, as had been mentioned earlier. To start the comparison, I would want to refer briefly to the Ghana-China BIT, which was signed in 1989, I believe. The Ghana-China BIT, which was signed in 1989, just to give a historical antecedent to the focus of bilateral investment treaties as it was then, and then trace to how it has developed in terms of content over time to this period. And so when you have a look at the Ghana-China BIT, which was signed in '89, or other BITs, I believe, involving other countries as well, from with investor states or home countries of investors, you would see that the focus is, apart from the usual definition of what an investment is, you come to compensation for expropriation, and then you come to most favored nation clauses, national treatment. Those are normal and dispute resolution are the focus of those investment treaties which were negotiated and signed in the past. Because it was signed basically with the aim or the mindset that it is the investor who will be fouled or who will be wronged. And so the investor must assume and must be given total protection without consideration to anything that involves the host country. And so, for instance, it's always been assumed that when it comes to BITs, it is normally the investors who invoke the dispute resolution clauses under BITs and not the home countries. The reason being that the drafting of the BIT, as it were, on the face of it, is such that it is one way to protect the investor. And because we in this part of the world are normally the host states, invariably, we don't have anything that we can hold the investor accountable to. So the historical antecedents of such BITs was in such a way that it was mostly geared towards the home country of the investors. Now, fast forward, you come with all the developments, all the things that has happened, you would see that with the new BITs that are being negotiated, there is an agenda to make sure that investors do not just come in and once the investment is caught or defined under the BIT, will just carry out their investments without recourse to national policy, irrespective or as long as that national policy is not discriminatory. And so you take, for instance, the ECOWAS protocols on investment, which was passed for the countries within the ECOWAS sub-region, where there is the focus on the developmental agenda. And so over time, you see that issues that have come to the fore of such bilateral investment treaties are not only limited to defining what investment is, or defining what, or how to calculate compensation if the investment is expropriated, or how to apply the most favored nation clauses, or the national treatment provisions, or dispute resolution clauses. You would see that there is an agenda towards the development of the home country, host country, as it were, so that the bilateral investment treaties should be an avenue, a springboard by which the host country, should be able to measure whether the investment fits into the whole national development agenda, in the sense that the investor will not be treated separately solely based on the provisions of the BIT, but the investment by the investor would fit into the overall national agenda of the host country. And I'm happy to say that at least since 2015 or a little bit earlier, most of the bilateral investment treaties, either intra-Africa or between African countries and other European or American or countries outside the continent, are focused on ensuring that the investments fit into the overall national agenda of these countries. And I would want us to narrow down on the Morocco-Nigeria BIT, which is a BIT that is between African countries. And so when you go to the recital of the Morocco-Nigeria BIT, you will notice very interesting recitals. And I may just refer to just a few of them. You would see that the recital is that recognizing the important contribution investment can make to, and these words are very key, sustainable development of the state parties, including the reduction of poverty, increase of productive capacity, economic growth, the transfer of technology, and in furtherance of human rights and human development. And so you see that this recital is telling us the overall motive or the intention of the parties to the BIT. And that is something that was missing in the BITs that were negotiated in the 80s, the 90s, and perhaps the early 2000s, the turn of the millennium. And so this preamble or recital to the Nigerian-Morocco BIT sets the agenda that your investment will not only be measured according to the profits that you make, so that in other words, we will not say whether your investment is profitable or not because you made profit, but we will determine whether or not your investment at the end of the day contributed to the overall sustainable development. And by sustainable development, you see keywords that are used there: transfer of technology, words such as, or if you read further in the BIT, words that concern labor, human rights, and making sure that the investment sits with the overall national development agenda of the country. And to that extent, you see that the Nigeria-Morocco BIT served as, for lack of a better word, a role model or a model a BIT for other countries, especially host countries, to look up to in terms of negotiating with the foreign countries. And so to that extent, you'd see the agenda shifting, as I had said before, and then being put in such a way that just merely defining what the investment is not enough. But if at the end of the period of the investment or in the course of the investment is deemed by the host country, again, without any form of discrimination, that it sits outside or it's not accommodated by the overall national development, then the host country has a right to question whether or not we should continue to give protection or other rights most favored nation clauses, or all the other terms that are thrown about in such bilateral investment treaties should be given any credence or should be given any traction in respect of that particular investment. You would also notice another example with the Ghana-Turkey BIT, which was signed in 2016, the Ghana-Turkey bilateral investment treaty, which was signed in 2016. And you'd see that the Nigeria-Moroccan one is intra-Africa, but the Ghana Turkey one is cross-continents, if lack of a better word. I would also want to read a preamble or part of the recital of the Ghana-Turkey BIT. You'd see in the third recital, recognizing that the promotion and reciprocal protection of investment under this agreement will be conducive to the stimulation of business initiative and will contribute to long-term sustainable, you see another key, and the same word used there, sustainable economic growth and development in both contracting parties, recognizing the importance of transfer of technology and human resource development arising from such investment. And so again, you would see another African country trying to ensure that the overall ambit of the investments sits with the national development agenda of that country. And key words that we have noticed in both the Nigeria-Morocco BIT and the Ghana-Turkey BIT is sustainable economic development. And so we look at words, environmental friendly. In the Nigerian BIT, the Nigeria-Morocco BIT, you will not be allowed to commence any investment or undertake any investment unless, for instance, you have provided an social impact assessment report, an environmental impact assessment report. And these are things that were previously not a requirement in any before any investment starts. But then you see that it is because the host country needs to determine whether your investment, irrespective of how much cash you are throwing into the economy or how much value you claim you have, the impact of your investment in the society, the impact of your investment on the environment. And so, for instance, if you want to come and mine bauxite in Ghana, and then you are not able to provide the impact of your investment and mining activities on the economy, it will affect the sustainable growth agenda, which has become an important element of the preamble or of the BIT as captured by the preamble of the BIT. And so it is fair to say that the countries are now, let's say fairly from 2000 and mid-2000 or from 2015, trying to situate the BITs as part or as a springboard or as a driving force behind sustainable economic investment, or sorry, behind sustainable economic growth, so that it is not enough for you just to come and throw in your investment. We must be able to measure your investment against the overall national agenda, overall national economic growth, and see whether we, even as a host country, want to entertain your investment. Another aspect of it is the dispute resolution. You will notice that the perception has always been in all the writers or in all the books that were investors are not comfortable having dispute resolution clauses from the home countries or the host countries. They always would want to choose international arbitration with a seat that is completely outside the host country of the investment. That has been the norm, that has been the thought. But if you take the Nigerian-Morocco BIT, you will notice that when it comes to settlement of dispute, there is the joint committee, which the parties must submit the dispute to. Membership of the joint committee is from both countries, and within 6 months to try and resolve the issue or the dispute. If it fails, an aggrieved party must exhaust all local remedies before an attempt is made at international arbitration. Yes, it can be said that that in itself, that clause in itself, may defeat the whole idea of having finality to dispute resolution, because then if you have to exhaust local remedies, is the international arbitration serving as an appellate fora for the decision of the local courts or the local remedies, or you would have to jettison the outcome of the discussions before the local courts or exhausting the local remedies. That is a topic for another discussion. But at least you see an attempt that once the dispute is generated as a result of the investment, the parties are obliged to attempt to solve the investment by using all available local remedies. And so certain ideas, certain concerns, such as the local courts or the local remedies are not enough, are being taken away. One very, very important thing that has also been stated in the Nigerian-Morocco BIT is the issue of corruption, which I think that it's about time that African countries enforce that aspect. You would see that in the UK, there is, and in America, if you're a UK-based or an American-based entity and you want to invest in, let's say, Africa, you would have to file a report of your activities. Anti-Bribery Corruption Act is enforced everywhere. And unfortunately, a lot of African countries have not included that in part of their BITs. And so when you always make reference to the case involving Kenya, where an award was set aside because the investor admitted under cross-examination during the hearing that they actually paid bribe. I think it's, Thierry, it's normally referred to as the duty-free. Yes, the duty-free case. That a whole award was set aside. The investment was obtained by fraud, corruption, and so the whole award was set aside. And so that is one key thing about corruption. I'm so happy that the Nigerians and the Moroccans included that in their BIT. And it is something that African countries must be very conscious so that there will be transparency in the investments. You do not have situations where local businessmen are shortchanged because there is an investor who is coming to town and the investor is able to work through the system, whether we like it or not, engage in corrupt practices, and gain undue advantage over local investors. And so if you look at the Nigerian-Morocco BIT, there's that provision that the national treatment or the MFN provisions would have to be measured against the treatment of local investments in like circumstances. Sorry, local investors in like circumstances. So that it is not enough for you just to come as a foreign investor and then claim that you've been discriminated or you should be given preferential treatment merely because you're a foreign investor. The Morocco-Nigeria BIT has that provision where the treatment measured out by the host country against local investors, that is nationals of that state, would be the threshold to determine whether or not the investor has been treated wrongly or in a discriminatory manner. And so in rounding up, the Nigeria-Morocco BIT has introduced provisions right from the preamble through to clauses relating to dispute resolution, the application of the MFN clauses, the national treatment clauses, more particularly corruption, to show that it is about time that host states make sure that in negotiating BITs, sustainable economic growth, the national agenda, is the focus. It is not merely about the investors coming to invest to take the profits away, but also about the host countries measuring the investment against the overall national agenda. So that you could come, we should have a situation where a host country should be able to initiate arbitration or dispute resolution against an investor because the investor has breached salient conditions of a BIT. So that if an investor engages in corrupt practices, it's about time that the host countries are able to initiate arbitration proceedings. That will let the investors from whatever part of the world they come from be on notice that it is the times where BITs are negotiated and applied in such a way as if the host countries have no say are a thing of the past. And that investment is supposed to be a win-win situation. At the end of the day, the focus should be sustainable economic growth and development of the host state. So those are my thoughts on the subject. First start.
Thank you very much, Bobby. Thank you for sharing with us the insight and comparison of current BIT and the one of 80s and before. Time will come for question and answer, either from the participant or why not from us. Let's now, and thank you for keeping time. Our second speaker is Giselle Stephenchou. Giselle is a dual qualified English and French lawyer with over 16 years experience in international arbitration. She worked at a global firm in London and Paris before establishing her independent practice. She has acted for corporate and state in over 40 commercial and investment disputes in many jurisdictions in Africa and around the world. Recent matters include the successful defense of the Republic of Kenya in an exceed arbitration and the reinstatement by the French Supreme Court of a $1 billion exceed award against Venezuela. If you need more about Giselle, as Dr. Imedia said, you check on the link about the bio of all speakers of this panel. Giselle will explore the tool African states can adopt in balancing their interest in attracting foreign investment and observing their regulatory space. Giselle, the floor is yours.
Thank you very much, Thierry. Thank you, Thierry. Thank you for the introduction, and the timing is noted. Thank you also to Emilia for the very kind invitation to participate in this wonderful event. Et un grand merci également au CIMAC pour l'organisation très efficace de cette conférence. I will be making my remarks in English, but will gladly take any questions in French or English later on. I do have some slides to share, so if you're just going to bear with me for a second. Are the slides visible? As you know, great. My topic is as Thierry explained, is looking at the available tools which states can use to carve out regulatory space, and I'm focusing here particularly on the space needed to take measures to promote domestic industries and development of domestic players. Now, it's fair to say that states around the world, not just in Africa, are currently taking initiatives to protect domestic markets and domestic businesses and resources. And that trend predated the pandemic, but it's certainly been accelerated by it. So the aspiration to localize or relocalize is by no means specific to Africa, but of course it's particularly critical for Africa's development goals to industrialize, to add value to African products, to cease importing expensive finished products, and to integrate better in the regional and global value chains. And of course, we heard a lot about that this morning in the very inspiring discussion of the first panel. And you'll see the quote from the African Development Bank on this first slide that essentially encapsulates all those aspirations. So there have been some recent policies in different African countries that have hit the headlines recently, a lot of them focusing around local content and similar initiatives. And these are just a few examples. There are, of course, many others. But for example, you have Senegal announcing an ambitious target to have, local companies representing 50% of oil and gas activities by 2030. In Nigeria, there's a long-standing policy known as backward integration, which essentially seeks to promote localized supply chains, and the sourcing of local raw materials in particular in different sectors. South Africa's recently announced plans and initiatives to promote local content by designating certain products as requiring 100% or 80% local content due to supporting local manufacturing. And in Algeria, the automotive industry, among others, has been facing several measures and initiatives from the government where the government is trying to promote local integration and kind of localization in Algeria of more significant parts of the automotive supply chain through heightened levels of integration with some pretty ambitious targets. So how do these sort of buy local, manufacture local policies sit with international investment law? Well, looking first at customary international law, there isn't too much of a difficulty in the sense that the customary international law provision, it's really a negative duty not to discriminate in any intentional manner, but customary international law does not require states to afford equal treatment to foreign investors as opposed to nationals. That positive obligation to afford equal treatment can be found, however, in specific provisions in investment treaties, such as national treatment and most favored nation provisions, and of course discrimination can be relevant to the assessment of violations of other treaty standards, such as fair and equitable treatment. Now, moving on from the kind of pure anti-discrimination protections in investment treaties, there are also in certain treaties, although it's a much rarer provision than a national treatment provision, provisions that prohibit the imposition of performance requirements. So, for example, taking one recent African treaty, which is the treaty from 2020 between Côte d'Ivoire and Japan, that has a prohibition on performance requirements targeting various types of measures and among those measures are included local content requirements. Of course, as we'll see, that the Côte d'Ivoire BIT then goes on to provide various sectoral and other exclusions to this prohibition on performance requirements. So in the face of these treaty protections, how do African states go about giving themselves enough space to regulate in a way that allows them to promote the development of local businesses, local players, and local industries? Well, there are a variety of tools. I mean, I think it's fair to say that provisions such as national treatment are among the provisions that are the least standard. There is really a very wide range of provisions across treaties and exceptions. So states, when they're negotiating a national treatment provision on a bilateral basis, they obviously, quite often, frequently negotiate specific subject matter and other similar types of exclusions. So exclude certain sectors, certain subject matters altogether from the protection of such provisions, such as national treatment. Another tool that can be used is to impose specific criteria for the application of the treaty protection. And we'll see some examples of drafting in relation to national treatment, which we'll come on to. Then, of course, there are often much more general exclusions in treaties, which don't only cover provisions such as national treatment, but treaty protections in general under the treaty. And finally, there are also so-called self-judging provisions. So I'm just going to run through these broad categories in the time available. So coming first to the specific exclusions, as I said, many treaties carve out certain types of measures, economic sectors or subject matters from national treatment and also most favored nation protection, and where those are present, prohibition on performance requirements. And here you have an example of these exclusions in the Côte d'Ivoire Japan BIT. where, and I should say this is really a kind of summary of the provisions, because to kind of analyze the provisions properly, you have to look at several different sections of the treaty. But typically, and this is the approach in the Côte d'Ivoire, Japan BIT, you have a statement that the national treatment and other relevant protections are inapplicable to any existing non-conforming measure, and that measure is specifically identified by each contracting state in a specific schedule, and what that does is effectively grandfathers any measure that predates the entry into force of the bilateral investment treaty, and essentially insulates that measure from any exposure to creating a violation of the BIT. But in addition to grandfathering pre-existing so-called non-conforming measures, you also find exclusions for the future. And again, as evidenced in this BIT, there is an exclusion for any measure to be adopted in the future by a contracting party, so by either Côte d'Ivoire or Japan, with respect to certain sectors and types of measures set out in a schedule. And looking at Côte d'Ivoire's schedule, you see that excluded from the ambit of national treatment, most favored nation, and or this prohibition on performance requirements, you see a range of different types of measures, such as the recruitment of local labor, which essentially preserves Côte d'Ivoire's ability to impose requirements of local content in respect of hiring local labor on foreign investors. And it also excludes the application of these treaty protections to specific sectors, which clearly Côte d'Ivoire has deemed to be strategic for its domestic interests, such as oil, mining, air transport, agriculture, and fisheries, which are sectors that one sees quite commonly excluded from the scope of national treatment and these other protections, whether it's Côte d'Ivoire, but there are a number of other states treaties that contain quite similar sectoral exclusions. So that's for the kind of exclusions that are specific to these types of protections. But then, states also in their toolbox have the ability to, draft national treatment provisions in a manner that's going to favor, that's going to be favorable to an interpretation that takes due account of their kind of socioeconomic developmental interests. And here I can only echo what Bobby said a moment ago about the national treatment provision in the Morocco-Nigeria BIT. I think it's a really interesting provision, because while a lot of, number of bilateral investment treaties do impose the existence of like circumstances, so they say that investors must establish that they are in like circumstances to an investor, a domestic investor that may have received more favorable treatment. While there is this reference to like circumstances, most treaties do not actually explain what that means and what that needs to take into account. And here, what you see in the Morocco-Nigeria BIT, and I should say this definition in this BIT is one that I've seen in various other African treaties. So I think it's something that's quite particular to African treaty making, and I think it's quite ingenious, because as Bobby said earlier, it doesn't focus only on the investment, the situation of the investment and the investor itself, but it also requires tribunals to take account of, in assessing like circumstances, to take account of the effects of the investment on the local community, the local environment, and to also take into account the regulatory purpose and process of the measure that is in dispute. So it really requires this sort of much more holistic approach that facilitates taking into account, states' kind of policy making and developmental objectives. And I should say it really does a great job, this provision of drawing on the learnings from investment treaty case law on what like circumstances mean and what it should take account of. As I was looking through recent African BITs, I also came across this provision, which I thought was quite interesting, the national treatment provision. I've never seen anything like it before. It's in the Ethiopia-Qatar BIT of 2017. And I have to say, it really restricts the scope of a violation of national treatment, because it subjects evidence of a violation of national treatment to evidence of intentional discrimination based on nationality. So that brings national treatment much closer to the sort of customary international law standard, and it really does restrict its scope, because I think as you will be aware, when it comes to assessing whether there has been a breach of national treatment, generally tribunals do not focus on or do not require evidence of an intent to discriminate. They really just focus on whether the measure has a discriminatory effect, but intent to discriminate is not required. So I thought this was an interesting provision, because it really waters down the national treatment protection. So moving on to more general exclusions, and so these are general exclusions that apply to all treaty provisions, not just provisions that target discriminatory measures, but nonetheless are obviously relevant and important in the present context. So, what we're talking about here is sort of exclusions for non-precluded measures, and this is sort of the general concept. And traditionally, and at its narrowest, when we talk about non-precluded measures, we're talking about essential security interests, and that is typically traditionally confined to fairly narrow interests around national security, war and defense interests, and so on. But what we're seeing now is a sort of general expansion of these clauses to cover other areas of general public welfare, such as health, safety, or the environment. So there's a general broadening of the kind of different areas in which these general exclusions might bite. The other thing I would add on that is that, apart from the kind of broadening of the different public welfare objectives that can be incorporated into these general exclusions from treaty protections, I think there's also the concept of allowing states to judge, discretion in determining what constitutes their essential security interests. And you have an example of that in the first paragraph of this provision, where you see nothing in this agreement shall prevent a contracting party from taking measures which it considers necessary for the protection of its essential security interests. And one thing to note about that is when you have a self-judging provision, well, of course, some states take more or less expansive approaches to what constitutes their essential security interests. And it's fair to say that the general trend now, is for states to broaden the definition of what is, belongs to their essential security interests well beyond the traditional areas of national security. And we can see that particularly in the kind of general legislative trends in terms of foreign investment and investment screening in particular. So just overall, I think we'll be seeing a very much a broadening of the scope of these general exclusions and increasingly recourse by states to self-check provisions that allow them to determine what constitutes their essential security interests. I'd just like to, in my run through these different examples of provisions in treaties and the tools that states can use to preserve their regulatory space in this area, I just wanted to refer to the Pan-African Investment Code, which does deploy a number of these tools. The Pan-African Investment Code contains a very similar definition of national treatment and like circumstances as the Morocco-Nigeria BIT, but it also includes a very interesting list of exceptions to the national treatment protection. Of course, some of those refer to some of these exceptions we've seen relating to different types of elements of public welfare. But it also has a really strong developmental focus. As you can see, it accepts from national treatment any measures, or preferential treatment to achieve national development objectives, and measures also excludes measures benefiting nationals within the framework of national development programs and the likes, or measures addressing the needs of designated disadvantaged persons, groups, or regions. So that's another interesting example of the types of tools that states can use to carve out that space necessary to ensure that the proper implementation of their local developmental agenda. Just to conclude, I'd just like to conclude on these recommendations from UNCTAD. So, obviously, UNCTAD has been advocating investment treaty reforms and kind of published some proposed investment policy responses specifically in the wake of COVID-19 pandemic, due to all the concerns raised that measures that states were taking at the time could to protect their domestic industry and local supply chains could expose them to investment claims. And so you see here that the suggestions to deploy these same tools that I've just given you an overview of, using policy exceptions to determine, in relation to civil, vital, economic sectors or industries, using self-judging exception clauses and the like. So I think it's fair to say that one effect the pandemic has had is to further focus the minds of states on further invigorating their initiatives to increase their regulatory space. And I would wager that treaty protections that target discriminatory conduct will themselves be a natural target for such reforms. So I'm expecting very much renewed activity in reviewing those provisions on national treatment and the other provisions I've mentioned in a way that's going to give states greater space to regulate in a way that furthers their local developmental interests. That concludes my remarks, and I'll be very happy to take any questions in due course.
Thank you, Giselle. Thank you for taking all of us through the tools African states can use and in their regulatory space. Thank you also for meeting the time +1, which is fine. I'm still fine with that. I'm going to invite the third speaker, who is Clara Brillenburg. Clara specializes in counseling sovereign state in international dispute with other states, foreign investor, and U.S. plaintiff. Mrs. Brillenburg is widely recognized for her expertise in international investment arbitration, most recently resulting in her selection as 2021 MVP of the Year for International Arbitration by Law 360. She has also successfully represented state before the ICJ in dispute involving territorial right, human right, and environmental harm. In addition, she has substantial experience counseling state in maritime boundaries dispute before the ICJ. For more about Clara, you can still go to the link and find the details about Clara Brillenburg. Clara, for now, will take us through the innovation in international international investment treaty that African states have adopted. Clara, the floor is yours.
Thank you very much, Thierry, and it's a pleasure to be here with all of you, speaking to you in the various time zones today. I've been asked to speak about environmental considerations in the negotiation of IIAs and investment contracts. And this is, of course, a very timely concept to discuss. So we've just seen hundreds of states participating in the 2021 UN Climate Change Conference in Glasgow. And the discussions finished with both renewed commitment and frankly, renewed concern for whether and how governments will meet those commitments. We've also heard many times over the United Nations Intergovernmental Panel on Climate Change issuing warning after warning of the need to take immediate steps to protect our environment, and the panel has now issued a quote code red warning that unless there are deep reductions in CO2 and other greenhouse gas emissions urgently, it will be impossible to stabilize global temperatures and achieve the internationally agreed threshold of 1.5 degrees Celsius of global warming. So the message is clear. Every fraction of a degree counts. Governments and people around the world must take aggressive action to protect our environment and must do so immediately. So this begs the question, what does this mean for international investment agreements and contracts in Africa? On the one hand, African states will need foreign investments to weather the literal and figurative storm brought by climate change. And on the other hand, it must take immediate and quite significant measures to protect the environment. So this transition, both to protect the planet, to protect the states and the people who live within it, and to protect investments and investment agreements must be handled with care. And many of us are familiar with the cautionary tale brought by Spain, which is now weaving its way through more than 40 arbitrations resulting from changes to the incentives and tariff regimes it put in place to attract foreign investment to the renewable energy sector. Another fact to keep in mind, if this is not done carefully and thoughtfully, is that 7 of the 10 largest awards in investment arbitration have been for fossil fuel companies, all of them ranging in the billions. So there is room for African states to take these actions, and they must do so. The question is how to do it thoughtfully and well. So what we know already is that African countries have concluded over 860 BITs, of which 160 are intra-African. So this actually represents almost 30% of the BIT universe. And in that universe, many African states have already sought to strike this balance that we're now looking to achieve. The breadth of these reforms, in fact, across the continent and their influence globally have led some commentators to refer to the Africanization of international investment law. And in this movement, we've seen and we continue to see environmental issues incorporated in three ways. And you've heard some about this already in regards to other themes, because the mechanisms can apply across the board from environmental protection to other issues of priority in the public interest. I'll transition here to some slides if you'll give me a moment. Forgive me, my computer is just taking this moment to ask me if I want to upload my virus protection, so not the best timing. All right. So, as I've said, there are three methods. The first is our clauses establishing rights and obligations concerning environmental protection and promotion. The second are clarifications and exceptions to substantive legal protections like FET and others that we've heard about today. And the third are procedural mechanisms. Now, before stepping into the specifics, I'd like to take a moment to step back to the wider concept of the state's right to regulate, which we're discussing. Now, investment arbitration jurisprudence affirms that customary international law principles allow states to have a wide in the realm of their police powers, including in the area of environment. As we've seen in Feldman v. Mexico, quote, a government must be free to act in the broader public interest through the protection of the environment and other areas. Reasonable governmental regulation of this type cannot be achieved if any business that is adversely affected may seek compensation. So that is the foundation upon which this all lies. However, what we've seen is that while states' right to regulate the environment and other areas of public interest is broadly recognized as the principle of customary international law, investment tribunals have, in fact, not uniformly acted in accepting these police powers. And so recently we saw in Santa Elena v. Costa Rica that the tribunal took a narrow approach to these police powers and concluding that the environmental purpose of a state's measure was in fact irrelevant to the question of whether compensation was owed under the expropriation standard, stating that where property is expropriated, even for environmental purposes, whether domestic or international, the state's obligation to pay compensation remains. Now, again, there is variety in this, and I like to point out that this stands in contrast to Chemtura v. Canada, where the tribunal found that Canada took, quote, measures within its mandate in a non-discriminatory manner, motivated by the increasing awareness of the dangers presented by lindane for human health and the environment. And these were found to be a valid exercise of police powers and a valid protection for the state taking this measure. So tribunals have also taken varying approaches when considering the proportionality of environmental measures and in permitting counterclaims for environmental damages. So what we know is that environmental provisions in the treaty can help minimize this variance between tribunals by giving both tribunals and foreign investors and states clear guidance on the rights and obligations arising from the treaty. So the first way we've seen is to include separate clauses to protect the environment in these treaties. And we see this across many African BITs. Of course, one of the earliest examples of this is the 2012 model BIT of the South African Development Community, SADC, which was among the first to impose obligations not only on the states, but also on investors. More recently, we've heard this reflected in other African BITs, starting with Nigeria and Morocco, which incorporated this in, for example, Article 14 of their BIT, which again goes straight to the issue of environment, where it says that investors and investments shall comply with environmental assessment screening and assessment processes applicable to their proposed investments prior to their establishment. So they have to, in order to execute an investment, they must comply with environmental protections and standards. The same Morocco, Nigeria, but which we've heard about earlier today, also requires investors to apply the precautionary principle to their environmental impact assessment and to decisions taken during the operation of the investment. It also includes post-establishment obligations, where the investor must maintain an environmental management system, and particularly in areas of resource exploitation and high-risk industrial enterprises, they have to maintain certain internationally recognized environmental standards. We've also heard discussed earlier the incorporation of general exception clauses. Here we have some clauses from the Tanzania-Turkey BIT and the United States-Oman BIT, where it specifically states that non-discriminatory legal measures designed and applied for the protection of human, animal, or plant life or health or the environment shall not be, that the treaty shall not be construed to stop a state, to prevent a state from taking those important measures. And of course, this can be applied to whatever sectors the government feels are sectors and measures that need to be given these types of protections. Now, I included the US-Oman BIT because that was part of a recent decision in Al-Tamimi versus Oman, where the tribunal really focused on this clause in order to understand and appreciate the premium that the states had placed on the importance of protecting the environment, which of course informed their consideration in the dispute. This of course extends, what we've seen also is non-African partners entering into international investment agreements and contracts with African states and pushing for these same goals together. Here we see a couple of examples from Canadian BITs with African states, starting with the general concept of encouraging corporate social responsibility, obviously incorporating environmental considerations. So here the language asks for the contracting party to encourage enterprises operating within its territory to voluntarily incorporate internationally recognized standards of corporate social responsibility. And I highlight here a couple of things. One, the clause specifically states that the state is merely encouraging, not necessarily mandating, and that it's encouraging the company to voluntarily incorporate these internationally recognized standards. And this language is obviously very intentional and focused on it being a voluntary and not compulsory. The Canada-Burkina Faso BIT goes certainly a step further, and in fact creates rights for the investor to pursue arbitration if the state breaches an obligation under the chapter of the treaty relating to health, safety, and environmental measures. We've also seen specific clauses going to environmental issues in the discussion of performance requirements, which Giselle just spoke of. In some treaties, we see that states are prohibited from requiring performance requirements. Here we see an incorporation of an exception that are prohibited unless such order, public health, or environmental concerns, and are enforced by a law of general application. So again, we see a very specific carve out relating to the environment and other areas of priority for this. The second, excuse me. The second way in which we see these methods being used in African BITs and otherwise is through the clarification and exceptions to existing substantive legal protections. And this is in fact the best way to complement the environment-specific clauses incorporated elsewhere. Ultimately, many of these treaties will be manifest themselves in disputes before international arbitration tribunals, which inevitably will apply these legal standards in determining whether the state has in fact violated its obligations. So this comes through is first in fair and equitable treatment to include specific measures and clearly state that environmental measures will not be considered unfavorable treatment in violation of the FET standards. And this provides the state greater ability to enact environmental measures without the risk of arbitration. We also see this specifically relating to expropriation, where in fact it's made that there is a clarification added to the Nigeria-Austria BIT, which says that it will be only in rare circumstances where the measure is extremely severe or has not been applied in good faith or has been applied discriminatorily, that measures designed and applied to protect the environment along with health and other public welfare objectives will not constitute indirect expropriation. This is a very clear language stating the intention of the state to protect its ability to regulate in the interests of the environment. We also have seen this in the discussion of the national treatment standard. Here I've included the Brazil-Ethiopia BIT, which specifically, for example, indicates that the determination of whether a host state has accorded foreign investors treatment equal to that accorded to its own investors, quote, depends on the totality of the circumstances, including whether the relevant treaty distinguishes between investors or investments on the basis of, again, legitimate public welfare objectives. And of course, this applies not only to the environment, but to many of the other areas that we've discussed today. The third mechanism is to think of ways in which procedural means and procedural mechanisms can be built within the treaty or any potential disputes such that the state has greater ability to regulate and there's more clarity on the rights and obligations of the parties relating to the environment. First, agreements can expressly limit their protections to those investors that actually comply with their environmental obligations. And we saw I bring up the example of Cortec Mining v. Kenya, because there Kenya successfully argued that the tribunal lacked jurisdiction because of the claimant's failure to obtain an environmental impact assessment and fulfill other environmental obligations required for its operations. So here we see obligations on the part of the investor in order to gain the protections of the treaty. Another option is to require tribunals to take the investor's lack of compliance with environmental obligations into consideration when assessing the compensation damages. In the India model BIT, for example, there's language which reduces damages to reflect mitigating measures, which specifically and expressly include, quote, any unremedied harm or damage that the investor has caused to the environment or local community or other relevant considerations regarding the need to balance public interests and the interests of the investor. And I find this very interesting because it raises very explicitly the importance of balancing these rights and interests and provides for a clear understanding of how that applies when it comes to assessing damages. And finally, of course, as has been raised by others today, there's building in the opportunity for states to potentially bring counterclaims for environmental violations. We've seen some states, Ecuador in particular, be able to raise this successfully in some disputes, but it's still exceedingly rare that this has been able to work, but increasingly occurring, and certainly increasingly occurring as more and more states include this, expressly include into their treaties the potential for states to bring counterclaims and counterclaims for specific breaches relating to the environment and other issues of public interest. In the end, international investment agreements and international contracts with foreign investors will have a very important role to play in the years ahead, both to provide African states with the framework to attract foreign investment to a greener economy, but also to provide both the investors and the states the flexibility to adopt the significant measures needed to protect the environment and to forestall the devastating impacts of climate change. I've aimed in this presentation to provide some ideas for how African states can navigate the bumpy road ahead and how they're already starting to. Thank you. I'll be happy to address any questions at the end of the discussion.
Thank you very much, Clara. Thank you for taking us through innovation that state can use to protect environment. Thank you very much for that. And thank you also for taking time. Our following speaker is well known by all of us, Professor Walid Ben Hamida. Ben Hamida is a professor of law at University of Paris-Saclay in France. He was a member of the International Chamber of Commerce, ICC, for 6 years. He served as an arbitrator, president of Arbitral Tribunal, expert and counsel in many cases in ICSID, ICC OHADA, and ad hoc rules. He is also a member of ICSID panel of conciliator and arbitrator nominated in major arbitral institution lists such as CCGA, KIAC, CMA, made authorized more than 90 publications in Arabic, French, and English language. He was visiting professor in more than 90 countries. Professor Walid Ben will focus on how other non-African experience, because you have seen that we went through all different experience of what is happening in Africa for now, for the current BIT compared to the last 20, 30 years BITs. For now, Professor Walid will lead us on how other African experience, such as NAFTA, European Union, can help African states to reform their investment treaty. The floor is yours, Professor Walid.
Thank you so much, Thierry, for your this introduction. I want to thank the organizers of this event for their kind invitation, especially Emilia and Dr. Hisham for their invitation. I am very happy to see old and new friends as speakers in this panel. The issue that I will deal with is the following. What can we learn from non-Africans to reform African investment treaties? What lesson could be learned in order to negotiate African investment treaties? I reviewed during the weekend many experiences, many practices, the European Union practice, the post-NAFTA experience, some Latin American countries practice. I also reviewed the work of Ancestral Group 3. We know that Ancestral creates a Group 3 to address reform related to investor-state dispute settlement. And during the sessions of the Ancestral Group 3, many countries provide submissions on their practices and on their positions with regard to the investment treaties. So we have an African proverb in French, l'herbe est toujours plus verte ailleurs. Grass is greener on the other side. So what can we learn from the other side to reform investment treaties in Africa? And we know that the question of reform is very important for Africans, because African states will start the negotiation of the African Protocol on Investment, the African Protocol on Investment within the Continental African Trade Agreements. The African or the Continental African Trade Agreements didn't include a chapter on investment, even if we find 13 references to investment in the text of the agreement. But the negotiators, the Continental Africa Agreement, decided to deal with investment in this African Investment Protocol. The negotiation of the Investment African Protocol is an opportunity to reform investment regime in Africa. It's an opportunity to conclude a state-of-the-art agreement, a modern and ambitious multilateral investment agreement that covers 54 countries. We know that the conclusion of multilateral agreement on investment is a very difficult task. Many initiatives did not succeed. We remember of the OECD multilateral investment agreement. We remember of the World Trade Organization initiative to conclude a multilateral investment agreement. All of them, they did not succeed to conclude the multilateral investment agreement. So we hope that Africa can succeed and can conclude this multilateral investment agreement. The African negotiators are very lucky because they have access to treaty practice. They can benefit from the experiences of many countries, of many negotiators in the world. Also, they have access to the case law, to the jurisprudence developed by many investment tribunals. They have access to 30 years of jurisprudence. So African negotiator, they are a true maker of the investment rules. They can react, they can correct, they can transform the investment regime that they want to establish. So reviewing the foreign experiences, what are the recommendations that could be formulated in order to improve the investment regime in Africa? I will try to give 4 recommendations, 4 lessons. The first one is related to the method of negotiation. The second one is related to the objective of the investment treaties in Africa, or is related to the global perspective of the system. The third recommendation is related to dispute settlement, and my last recommendation is dedicated to the problem of consistency. So let's start. My first lesson or my first recommendation from non-Africans is the method of work, is the method of negotiation of investment treaties. The process of negotiation in many countries, as the European Union, is transparent, open, and inclusive. And I think that in Africa, we should follow the same approach. We should follow the same approach when we negotiate African investment treaties with Africa, between us, with third countries, and when we negotiate the African Investment Protocol. We should communicate, we should use internet, post on the website the draft of the agreement, the studies, the state positions. We should be inclusive, involve all the parties, states, private parties, business community, social society, non-governmental organization, and experts. And maybe we should find a more transparent solution to select the expert that will be involved in the negotiation. And we can also ask the public to comment. You know that there is a debate today on the democratization of investment agreement. So sometimes it's very interesting to listen to the public and to give the academia, the public, an opportunity to give or to provide their position. That's the methodology used by ICSID when it reforms its arbitral rules. ICSID asks the public to comment on the different drafts of the rules. So we should avoid negotiating behind the closed door. Be open be transparent and with regular communication. I add that the preamble of the African Continental Free Trade Agreement mentioned a transparent investment rules. So transparency is very important value that we should take into consideration when we negotiate African investment treaties. That is my first recommendation on the method of work. Now, let's move to the content of the agreement, issue of substance. What can we learn? My second lesson or my second recommendation is related to the perspective or the objective of the agreement. And here we have a debate between two approaches. The first is the promotion approach. The second one is the protection approach. When we negotiate African investment treaties and the African investment protocol, do we need protection agreement or facilitation or promotion agreement? Or maybe we should include both protection and facilitation approach. The question should be raised because if the objective of the African protocol is to protect inter-African investment, we should keep in mind that inter-African investment is very small. According to a study made by the African Development Bank, the majority of investors come from 4 countries, 4 home countries. We have South Africa, Morocco, Nigeria, and Kenya, the top home countries. And the top 4 investment host countries are Nigeria, Mozambique, Ghana, and Ethiopia. These countries get about 44% of total African investment. So the inter-African investment is small and is shared by those countries. Second comment, we have few investment arbitration case initiated by African investors against African countries. We have maximum 10 investment or inter-African investment case. And why? Because as I told you, the inter-African investment is small, and because many inter-African investment treaties are not into force. According to UNCTAD, we have 190 inter-African BITs, and 130 are not into force. So we have a few inter-African investment cases, and some of them are initiated by what I call formal African investors. That means that we have a company that is incorporated in an African country that use an African investment treaty to initiate arbitration against another African country. So the money comes from a third country, not from Africa. We know that many investors, they use African countries as a bridge to structure their investment and to take benefit of taxation agreement, and sometimes to take benefit of investment agreement. So maybe the objective must be facilitation of the investment, not protection, because we don't have inter-African investment. We should maybe focus on the facilitation, on the promotion approach. We know that today we have 2 approaches. We have the protection, that's the traditional approach, but we have also a new approach followed by some countries like Brazil that focus on promotion of investment, facilitation of investment. The African Continental Agreement mentioned in the preamble the elimination of non-tariffs barriers to trade and investment. And Article 3 of the same agreement provides that one of the objectives of the Continental African Free Trade Agreement is to facilitate investment. So which approach, promotion or protection or both, promotion and protection? Second issue is, as I told you, the most foreign investment in Africa is concentrated on natural resources and comes from non-African countries. In the African protocol that we will negotiate, maybe we can cover both non-African investment and African investment, non-African investors and African investors. The European Union investment approach is a global. The European Union approach deals with both European investment and non-European investment. The European investors and the non-European investors, maybe we should follow this approach, because the most important investment in Africa is made by non-African, is made by investors that are not from Africa. Another issue that we want to avoid all the time is taxation of investment. And we have a traditional approach that deals with taxation and investment in two separate agreements. Taxation agreement deal with tax issues, and investment agreement deal with the investment, but they are connected. And maybe we should take into consideration the taxation dimension and include in the protocol some rules related to the taxation. So 3 questions here to deal with. The first issue is facilitation or protection. The second one, how to deal with third country investment. And the last one, should we provide rules for taxation in the next African investment protocol? This is my second lesson on the perspective or the objectives of the investment agreement. Let's move now to the third lesson or the third recommendation. And my third recommendation is dedicated to the dispute settlement mechanism. Many questions. The first is, do we need arbitration to settle inter-African investment disputes? Why this question? Because in Europe, in the United States, in Canada, they are killing the investor-state arbitration. The European Court of Justice found that the investor-state arbitration clause could not be used to settle investment between a European investor and another European state, because the court said, because it is against the European law. That's mean because it's against a law created by the European states, and this law gives them an exemption from enforcement of arbitral awards. Many European states lost some investment case before arbitral tribunal, and now they are using the European law to block the enforcement of the award. Thank you, Europe, for giving us this exemption of enforcement based on the law. Imagine that an African court or an African regional court takes the same position, enforcing or blocking the enforcement of arbitral award using regional African law. What will be the reaction? Then on May 2020, 23 members of the European Union, they decided to terminate the intra-European bilateral investment treaties. So they don't have investment treaties between them. And even if the investment treaties with the third countries, the European Union is removing the investor-state arbitration. The European Union is promoting a court system with a court of appeal. So in United States also, the agreement between Canada, United States, and Canada and Mexico, they replaces that replaces NAFTA, removed the investor-state arbitration, And we cannot, or Canadian cannot use arbitration against the United States, and American cannot use arbitration against Canada. So there is no arbitration between them. If the European, they don't like the investor-state arbitration, the American, the Canadian, do we need an arbitration system in Africa? On this issue, during the Group 3 session, the states adopted many positions on the appropriate dispute settlement mechanism. Some states, they proposed mediation. Some states, they proposed state court to settle investment disputes by local courts. Some states, they proposed the use of investor-state arbitration, as we know, sometimes with some modifications. We have also a debate on new regional courts with appeal, or sometimes they propose state-to-state system to settle a dispute between state and investors. And some African states, they propose the establishment of an open bilateral investment dispute settlement mechanism, because until now, the dispute settlement mechanism is open only for the investor against the state. Some states, they want a bilateral mechanism of dispute settlement. That means it's open for the state against the investor and for the investor against the state, not only for the investor against the state. So the solution, in my opinion, could be the instauration of a system à la carte that give to each state, by opting in, opting out, a possibility to select the appropriate mechanism. Whatever the dispute settlement adopted, 3 issues should be dealt with. 3 issues: diversity, time, and cost. First issue, the lack of diversity. Few Africans are arbitrators. The majority of them are nominated by the arbitral institutions and not by the parties. And few law firms from Africa are represented in dispute settlement related to investment. Sometimes we have a dispute between an African investor against an African state. The 3 arbitrators are not Africans. The lawyers that represent the parties are not Africans. The language is not African, and the seat is not in Africa. It's like settling a dispute between a Spanish investor against Poland by a tribunal of 3 Africans, Egyptian, Nigerian, and Tunisian, and the lawyers are from Ethiopia and Ghana. I am not aware of any example like that in Europe. Even if in our dream, it is very difficult to imagine such scenario. And to deal with this challenge, I think that the investment agreements must provide for a new rule in the text of the agreement that requires at least the participation of at least 1 arbitrators, 1 African arbitrators, to promote diversity. African negotiators should take a proactive approach to transform the practice and change the mentalities. And many European treaties, especially in trade treaties, they provide rules on nationality of the arbitrators, 1 from Europe, 1 from the other country, and the president is from a 3rd country. There is also another problem, the problem of linguistic diversity. The majority of arbitral awards are in English, and many states during Group 3 negotiation said that there is a problem of equal access to the legal framework in investment. They require translation of the most relevant words because they have a problem to understand the jurisprudence that is in English. That's the first issue. The second issue is time. We observe today that many arbitral institutions decided to reduce the deadlines related to the dispute settlement. And this could raise problems for some African countries. They need time to understand the request for arbitration, to plan their budget, to react, to select law firm. Sometimes they have to observe administrative law that provides for public tenders to select the law firm. They have to take time to nominate the arbitrators, to invoke the dispositive motion mechanism under Article 41 of the ICSID. And many African states, they don't have the capacity to manage investment dispute. And the new protocol must deal with this problem. It will be helpful to establish a mechanism for supporting and assisting those countries to deal with the dispute settlement. Maybe regional school on dispute settlement to assist African to deal with the dispute settlement and give them some practical background in order to deal with the dispute will be a good solution. The last issue related to the dispute settlement mechanism is the cost. Investment arbitration becomes a big business. It's a huge market. Some experts mention that we are living the industrialization of investment arbitration. And investment arbitration is becoming, according to some experts, a cash machine. We know that investor-state arbitration costs more for African than for non-African because all African countries use private legal services and they have to pay for that. In contrast, developed countries like United States, Spain, and Canada, and Italy, they have their own team to deal with investment dispute. They can control the cost. We should keep in mind that the objective of the dispute settlement is to provide a fair and equitable settlement of dispute. The system, in my opinion, must be guided by justice consideration and not guided by cash or money consideration. What are the solutions that could be used to mitigate the cost? During the work of UNCITRAL, there are many solutions. Maybe we should, in the treaty, regulate the councils and the arbitrators' fees. Maybe we can propose to pay the legal fees with local money. Maybe we can think or use the interstate arbitration rules according to which the cost must be shared between the party. We should include rules related to the cost in the treaty in order to deal with this challenge. My last lesson or recommendation is related to consistency. We have two consistencies, in my opinion, to deal with. The consistency between the investment instrument. This is the problem of spaghetti ball. We have in Africa many levels of protections. We have national investment codes. We have agreements, international agreements related to investment. And within the investment agreements, we have the inter-African investment agreement, the extra-African investment agreement, the semi-African investment agreement, the bilateral investment agreement, the regional investment agreement. We have also many investment related agreements developed by a regional group like COMESA or SADC. So we have to deal with this consistency between instrument or investment instrument. But we have also another consistency, the consistency between investment agreements and non-investment agreements. For example, many trade agreements provide for investment rules, the GATS, for example, but also the Protocol on Trade in Services under the African Continental Agreements cover investments. The commercial presence is a form of investment. So we have to settle this issue of consistency by providing rules of coordination between different rules related to investment and also between some rules that are provided in non-investment instrument, but they are linked to investment. One of the objectives of the African trade agreement, continental trade agreement, is to establish clear, transparent, predictable system of rules. And here, it is very easy to add the protocol to the instrument that already exists, but this will create a problem of coordination between the different rules that are connected. So here, multilateralism offers an opportunity to deal with this problem seriously. By consistency, I come to the end of this presentation. Thank you for listening.
Thank you very much, Professor Ben. You can see that you took more than 10 minutes, but nobody realized because of the content of what you were sharing with us. I was checking whether there is some question around here on discussions, but in meantime,
looks like you've lost your chair. So I'll just, oh, perfect. Thierry, are you back? You're mute.
yes.
Thierry, we lost you a few seconds.
I was saying that I would like to hand it to you for now, after 30 minutes of Professor Ben Walib, who later than using 20 minutes, he used 30, but
so
nobody
sorry.
realized.
Oh,
Nobody
so
realized because of the content was
That's
so
a problem
interesting.
of method of work. So
okay. Professor Emilia, I'm handing to you.
Thank you very much, Thierry. That's the advantage of having the professor go last. So I was wondering, we don't have any questions, but if anybody has any questions, please ask. If anybody wants to make a comment, please raise your hand. We would see you. We would ask you to please speak. Can I ask Zuhair to please release the poll? Let's just get a sense of what our attendees think of the topic. Can participants please complete the poll? And while you're completing the poll, I suppose I can ask a couple of questions to the panel generally. And it appears from the discussions and the presentations that we heard that the panel seems to agree that the African states themselves have the power to determine what it is they want out of their investment agreements. And so I want to ask the panel, for the first, second, third generation international investment agreements or treaties that African states are saddled with, what would be your recommendation to African states? What should they do with those investment treaties while our participants are completing the poll?
I'm happy to begin to address this. You know, as I said in my discussion, almost 30% of existing international investment agreements do involve African states. And so there's already a large number of agreements which have been concluded. And many of these, because they're older, were not quite as proactive in contemplating environmental and other public interest issues. I think I enjoyed how Professor Ben Hamida pointed out the main sources of foreign investment and also the main sources receiving them. I think a useful exercise that every state and every African state could conduct is to see, what foreign states are their main sources of foreign investment falling in within these treaties, identify then, what are the top 3, 5, whatever number of investment treaties related to the actual investments coming in, and then enter into discussions with those states, either to enter into new treaties or to enter into, if that is too difficult or involved in exercise, to enter into letters of agreement interpreting or clarifying or amending the existing agreements that they have. And sometimes that can be a much more attainable and practical way of proceeding. Or if in fact there are very specific issues or clauses or clarifications that a state wishes to make on very specific issues like national treatment or MFN, then they reach out to strategically to their top partners to see if they can in agreement. And frankly, as has been discussed today, a lot of countries around the world are looking to move forward in these areas, especially following the pandemic. And so they might see a lot more room for opportunity there.
Many thanks, Clara. I think Giselle wants to come in and say something.
Yeah, and sorry, my camera's off because I'm having a few connection issues. I just wanted to echo and perhaps just comment further on what Clara has just said. I think speaking from the perspective of European Union treaty making at the moment, they've put kind of sustainable development objectives very much very high up on the agenda, and you can see that in initiatives such as the Dutch bilateral investment treaty that was published. I think it was a couple of years ago now. So in a sense, I'd encourage African states to take capital exporting states in Europe in particular, at their word and engage in those discussions with them to reform their existing treaties, on the basis that everyone now has an interest in ensuring sustainable development objectives.
Thank you very much, Giselle. We have the results of the poll in, but before we go to the polls, I wanted to just remind us that this morning with the keynote speech from Ambassador Namira, we actually pushed her a little bit regarding the investment protocol and the fact that it is not publicly available. And she pushed back and said that until they finish, the negotiations and publish a text, of course, an agreed text. The concerns of the African negotiators, from what she said, it's this whole idea of different versions of the draft flying all over the place. It would be interesting to know, because we all know that even India put out their draft model BIT and gave a timeline for people to send comments. And we know that that is the future. So it might be useful as part of the summary or recommendations, if we like, from our conference, is to suggest to the AU and to the Africa Continental Free Trade Area Secretariat to figure out how other jurisdictions are dealing with those particular concerns. But it's helpful that Professor Walid has re-emphasized and spent some time to explain why transparency is important, why inclusion and including the voices, especially of those who would be primarily impacted by the outcome of those discussions, why our voices need to be heard. But unlike this panel, where we have gender parity to a certain extent, we're still moving in that direction as it relates to African organizations and institutions. Zuhair, I think we can now see, the results of the poll. So the results of the poll, can I just say, I can say it, thank you. So can I say that I'm sure the panel can see their results. We're getting too many 100%. I'm sure Professor Walid does not give any of his students 100%. And no law student gets 100% anywhere. Panel got 100% with, whether you clearly addressed the topic. I fully agree. I think it was very clear and it was not rushed. And I must thank the moderator for not rushing you, and even the speakers did not rush themselves. And then it said, were the topics useful for your practice and education? 95%, which is very high, said yes. We then asked, should African states renegotiate their old investment treaties? 95% said yes, and I think that's the view of the panel as well. It will be very interesting to understand the one person that said no, why they felt that African states should continue to be saddled with the old treaties. Thank you so very, very much for that response. Thierry, do you want to give your panelists one last minute to say anything else they want to say before we conclude the panel and invite Amani to come and speak on the ERA pledge? Or do you want me to invite Amani now? We can't hear you, Thierry. Sorry, you're on mute.
Yeah, okay, I'm deactivated now. Thank you very much to the panelists. It's just one word. I'm happy that people have found the speaker clearly of what they expressed. And that is the only measurement to use for me. Thanking all of you. Thank you, Emilia.
Thank you very much. It's left for me to add my own thanks. And thank you. This is Clara's first Arbitration in Africa conference that she's attending. So I hope you've thoroughly enjoyed it, and we look forward to having you back. And please,
first and certainly not my last.
Very good. Please let Taffy know that that you represented for LEHOAG very well. Thank you, Giselle. Thank you, Bobby. Thank you, Professor Ben Walida, Hamida, for all the exposition of the question. And you've raised very important issues, which we hope that those who will do summaries and that we will publish, that the relevant people who can do something about some of this will take all of that into account. And that brings us to the end of our second panel. We will now invite Amani to come and speak a little bit on the ERA pledge. The ERA pledge is the Equal Representation in Arbitration pledge, which seeks to promote females' gender, gender parity in international arbitration. Doesn't look like we have Amani, but that's fine. That's not a problem. One of the things we're struggling with is time difference and time zones. So what I would do is, I'm also a member of the Africa Committee of the ERA pledge. I shall not pretend that I can speak on behalf of Amani. So what I'll do is on the chat, I will put the link to the ERA pledge. The ERA pledge ultimately is a pledge similar to the African Promise. Remember that I said the African Promise pulled from the ERA pledge. The ERA pledge focuses on the appointment of female adjudicators. I think we now use the word adjudicators so that we can include mediators, arbitrators, auditors into that, that grouping. And the idea is for colleagues to sign up and basically promising that they will seriously consider appointing a female adjudicator. Of course, we're talking about qualified individuals, and that is important. And we can't talk about diversity without mentioning intersectionality. And Professor Walid already referred to that. It's important that it's not only female, how did I describe it? Female pale, not still, but female pale. We want females of all nationalities. That's massively important. And so our sessions today have come to an end. We had our keynote speech this morning, which focused on dispute settlement mechanisms within the Africa Continental Free Trade Area. We then moved on to our first panel. Our first panel looked at questions of economic and social development of African states and investment in the context of the Africa Continental Free Trade Area. We had Stephanie speak to us on the need for us to drink coffee from proper mugs and not use paper cups. One of the things, of course, with greener arbitration is that the conditions on the continent is very different from that in the global north. And the sorts of wastages that we see in the global north, we don't see on the continent for very practical reasons. And so in going green on the continent, we may need to have different considerations than those in the global north would need to deal with. And we then, of course, had just listened to this another excellent panel. So we are very grateful. What our panelists have done now is they've looked at the content of international investment agreement, primarily investment treaties, and what lessons we can learn and how African states can improve their traction in that space. Tomorrow we will continue with our conference. We usually have, our conference runs over 2 days. Tomorrow we have 3 panels. We're not starting as early as we did today. Tomorrow we're going to start at Casablanca 9:30 in the morning. So you just get additional 30 minutes to lie in a little bit more. And so we'll start with our 3rd panel, and that panel will be chaired by Wairimu Karanja. If you know Wairimu, I have more hair on my head than she does, which means none. And she just looks amazing with the way she wears her non-hair head. So Wairimu will chair panel 3 tomorrow. They will continue on the theme of panel 2. They will then begin to look at practically African states and international investment arbitration. And so the experiences of African states in international investment arbitration. After lunch, we would move on to mediation. And I had said that out of this conference series, we have a mediation group. And those are colleagues who are particularly interested in mediation. I think they have more than 200 members. So I've been receiving loads of emails. You know, they need to attend their own panel. So we're hoping that they will attend and they would engage with their panel. They put that program together.
Dans le cadre de ce panel.
At how African states can promote domestic and cross-border mediation. They would also talk about the Singapore Mediation Convention. Following that, after lunch, we would have our own panel where I will be speaking and we'll be looking at African states and dispute avoidance. We'll pick up on some of the issues that you have also, your panel has raised today on how better African states can prepare with negotiating investment treaties and stuff like that. So thank you very, very much. We will see you tomorrow. And many, many, many thanks to our speakers and to Thierry for doing an excellent job. We're grateful. Thank you. So this brings us to the end of today's program.